So, basically, the talk of today will be about democratic erosion, abusive constitutionalism, and the use of the unconstitutional constitutional amendments doctrine. You let me know?
Yeah.
Okay, great. So, as we know, in recent years, what we see worldwide is populist leaders abusing legal and constitutional mechanisms in order to undermine the democratic order. And this is usually done very gradually, incrementally, in very subtle ways, in a manner that the whole is greater than the sum of its parts. This is what we see. And one of the main means or mechanisms for undermining the democratic order nowadays is the use or abuse of the constitutional amendment procedure, especially if the amendment procedure, like in Hungary, is a relatively flexible one in which the government or one dominant party controls. Then it's very easy to use the amendment procedure and use it to undermine the constitutional and democratic order. I just want to go to some definitions, and I want to use Tom Ginsburg in his recent book, How to Save a Liberal Democracy, or How to Save a Constitutional Democracy, and they explain democratic erosion in the following terms. A process of incremental, but ultimately still substantial decay in three basic predicates of democracy: competitive election, liberal rights, such as speech and association, and the rule of law. And in the book they mention Hungary, Turkey, Poland, and Venezuela as examples for countries in which such a process takes place. Now, what is interesting about constitutional decay or democratic erosion as we see nowadays, in the past, autocratic leaders were objective to constitutionalism. They regarded constitution as something that limits their power. They were against constitutionalism. Nowadays, we see the opposite. We see these wannabe autocrat leaders loving constitutionalism. They love the constitutions and they use it. They use the constitution and abuse it in order to perpetuate their stay in power, to eliminate opposition, to quieten opposition or media, to undermine various institutions of checks and balances, such as courts, etc. So there is a complex relationship between constitutionalism and nowadays these populist leaders as we see. And here I'm getting to the main point of the paper. So the most common employed mechanism for what we see now is formal constitutional change. Formal constitutional amendments. Formal changes to the Constitution in a way, again, that creates erosion of the democratic order. If this is the tool that is now being used, then at least prima facie, the doctrine of limits to constitutional change, the unconstitutional constitutional amendments doctrine, seems like a useful tool to stop this type of abusive constitutionalism. Is it? So in the paper, what I actually want to do, and this is a paper I'm co-authoring with Tamara Ostrovsky-Brandes, we want to show that actually the doctrine is very much limited in the current wave of populist constitutionalism, and we try to maybe suggest things how to improve the doctrine in order to combat what we see as abusive constitutionalism. So let me say just a few words first about this doctrine of unconstitutional constitutional amendments. Basically, the doctrine of unconstitutional amendments focuses on certain limits to formal constitutional change. There are certain things, according to the doctrine, that are against formal constitutional change. Certain things in the constitutional order are not supposed to be open to change, to formal change. Like the candles of Hanukkah, you can only watch them, you cannot touch them, you cannot change them. Okay? Now these are sometimes explicitly written in the Constitution. For example, in Germany, the Grundgesetz, right, in Article 79.3, states that human dignity and the basic characters of the constitutional order are untouchable. Whatever changes you do to the constitutional order, they cannot affect human dignity. Sometimes it is not explicitly written in the Constitution, but courts around the world have declared that there is a core of fundamental values that are implicitly untouchable. They are eternal in a way. Most famously, this occurred in India, where the Supreme Court developed this basic structure doctrine. Whatever changes Parliament does to the Constitution, they cannot affect the basic structure of the Constitution in order to change the identity of the Constitution. So we have these changes, and these limits to constitutional change, these doctrines, are very often enforced by courts who declare sometimes certain constitutional amendments to be unconstitutional precisely for violating such fundamental values of the constitutional order. This occurs quite frequently in Brazil, in Colombia, in India, in Bangladesh. So this doctrine of limits to formal constitutional change can be a useful tool to combat abusive constitutionalism. And here I just want to give 2 or 3 examples. Recently, in Uganda, the parliament amended the constitution in order to extend its term from 5 to 7 years, because why not, if it has the power. The court, without any explicit authority, said, excuse me, you are abusing your constituent power, you cannot do that. You're undermining the basic principles of our democratic order, and invalidate that constitutional amendment. A similar process occurred in Taiwan in 1999, where the National Assembly extended its term. Again, this was blocked by the Grand Chamber of Justices in Taiwan in 2000. In Colombia. So in Colombia, the Constitution said the president can serve only 1 term. There was a term limit. But Uribe, who was a very popular president, said, well, I'm popular, why not to change the Constitution in a way that would allow me to run for a 2nd term? He amended the Constitution that way, and the Supreme Court allowed it. After finishing the 2nd term, he said, well, actually, that was quite nice. Why not push for a 3rd term? Uribe amended the Constitution to run for a 3rd term. This time, the court said, no, you're pushing the boundaries. You cannot do this because this would empty the very idea of presidential term limits. So in Colombia, the Constitutional Court, the Constitutional Chamber of the Constitutional Court, declared that amendment to be an unconstitutional constitutional change. And if we're going back to India, 1960s, 1970s, during the emergency time of Indira Gandhi, the court was actually quite useful in blocking various constitutional amendments that were undermining the rule of law and separation of powers. So prima facie, if you look at that, the doctrine could be a useful tool to fight abusive constitutionalism, to protect democracy. Is it? I'm claiming that no. That actually, facing what we see nowadays as populist constitutionalism, the doctrine is fairly limited. It is limited for 3 main reasons. The first reason is incrementalism. Nowadays, democracies die quietly by abusing subtle legal means. If you're a visitor who's coming from the outside or an alien and you're looking at a state that is currently undergoing a process of democratic erosion, everything looks fine. Everything looks okay. Why? Because there are no tanks in the street, right? This is not like what used to be when if a leader wanted to take over, he used sheer power, sheer force. There were tanks on the street, there were coup d'etats, etc. No, this is gone. Now we are abusing legal means, and if you're looking at the state, you cannot detect this process of democratic erosion, precisely because it is done incrementally. This is the first reason why the doctrine is useless, because the main function of the doctrine is to stop revolutionary changes to the constitutional order. The doctrine aims to combat abuse of the amendment power in a way that fundamentally abandons protected values. Right? The main question is, are we still living under the same constitution or not, before and after the change? But nowadays this is not what we have. We do not have such revolutionary constitutional amendments. We have minor constitutional change that maybe deviate or infringe some values or principles, but there is no substantive or extensive infringement of such protected fundamental values, and that's a problem. So democracy slowly dies, and the doctrine stands aside helplessly without the ability to intervene, precisely because these changes are incremental and subtle. Sorry. The second problem why the doctrine is useless is constitutional replacement. So the doctrine of unconstitutional change tells the parliament there are certain things you cannot do through the formal amendment procedures. You cannot undermine the basic principles, bless you, of the constitutional order. You cannot totally replace the constitution by using constitutional amendments. So then these leaders say, oh, I can't use formal constitutional amendments? Not a problem. I'll just bring a whole new constitution. I will completely replace the constitution with a new one. That's what Chavez did in Venezuela. That's what the Hungarian Fidesz party just did. They controlled the amendment process, and they said in 2011, we'll just bring a new fundamental law. And the doctrine is useless when it faces a complete constitutional replacement, because theoretically, we the people who exercise primary constituent power, we do not have any constitutional limitations on our power. The main strength of the doctrine lies precisely in this distinction between primary constituent power of the people and those delegated authorities that have a more limited power simply to amend the Constitution. So facing a complete constitutional replacement, the doctrine is useless. The third problem is attacking and packing courts. The doctrine, the Unconstitutional Amendment doctrine, shifts the locus of constitutional change from politicians to the court. They make, in general, they make the court the final arbitrators of society's values, right? They strengthen the court vis-a-vis other branches. This is one of the strengths of the doctrine, but also one of its weaknesses with what we see now. Because what we see now, the leaders said, if we can't fight the courts, we'll join them. We'll just pack the court. We'll control the court. So they put more judges of their own to the court. They decrease the retirement age, for example. So Chavez did that in Venezuela. We see it in Turkey. We see it in Hungary. We certainly see it now in Poland, where the politicians simply capture or pack the court. They take control of the court. This is what we call constitutional capture nowadays. And this is a problem for the doctrine, because if we trust the judges and the courts to save democracy by using the doctrine, if the judges are captured by the politicians, then the doctrine is useless. It is even worse than that. Not only that the doctrine is useless, but it is actually now open to abuse by the court itself. I'll give you just a few examples. So what we see now in Latin America, courts in Nicaragua, with Daniel Ortega, in Bolivia, and in Honduras, courts have declared that presidential term limits themselves are unconstitutional, allowing the presidents, the incumbent presidents, to run for re-elections. Why? Because the doctrine gives the judges amazing power to override constitutional rules. So for the leaders, this is amazing. Now they have just another tool in their toolkit to undermine the democratic order and get more control of it. So this is a doctrine. These are the main challenges of the doctrine as we see it. What can we do about it? Or can we do anything about it? How am I with time? 7 minutes. That's exactly what I mean. So what we propose a new thinking of the judicial role in applying the Unconstitutional Amendment doctrine. And here, in order to relax these challenges, we just open a debate about rethinking 3 aspects. The first aspect is that we think the judicial review of amendments should be carried out in an aggregated manner, an aggregated judicial review of amendments. Let me give you an example. Let's say that there is a change of the electoral threshold. Let's say increasing it from 2% to 3.2%. On itself, this change seems okay. It could be a bad or a negative, but it doesn't undermine the basic principles of the constitutional order. Likewise, if you decrease it from 3.2 to 2%, a reasonable change. But what if you change this electoral threshold towards every election in a way that gives you better chances to be elected? This, to our mind, is abuse of the constituent power. This is an unconstitutional constitutional change. But if you examine each change on its own, it is completely constitutional. It is fine. What we need is an aggregated judicial review that will take into consideration not just the current change that is now being challenged before the court, but also the context and past changes that have taken place. And what we think that this is precisely what happened in Colombia, for example, with the term limits. When the court said a second term for Urag is okay, but a third term is wrong, why? What's the difference? It is precisely this aggregated manner by which this constitutional change affected the constitutional order. And likewise in Israel, think about the change from an annual budget to biannual budget. This is a change that elevated the power of the executive, of the government, vis-a-vis the legislature, who was supposed to supervise the budget. The court, when the parliament changed the annual budget to a biannual one for the second time, the court said, that's fine. For the third time, it was fine. For the fourth time, it was fine. But for the fifth time, the court said, excuse me, dear Knesset, you are now abusing your constituent power. You cannot do that. So this is, to our mind, an aggregated judicial review without explicitly acknowledging that. In a way, it is the quality that makes the quantity that makes quality, if you want. Yeah, kamut הפכה לאיכות. So this is one change that we think that is valuable. Another one is review of constitutional replacement. Let's go back to the Hungarian example. Let's say I amend the Constitution by using the 2/3 amendment procedure to undermine the rule of law or separation of powers. Using the doctrine, such a change could be considered as an unconstitutional constitutional change. But if I use the same procedure in order to completely replace the Constitution, then the doctrine is useless. And we're asking why. It doesn't make sense. Using the same procedure to bring to a similar result, but simply labeling one as replacement rather than as amendment doesn't make sense. This is an absurd result. So we think that also formal constitutional replacement should be under judicial scrutiny. Now this is of course a very complicated issue, and we raise various options or standards how to do it, but this is something that we think is necessary. The third possible solution is to pay special attention to amendments that affect judicial independence. Until recently, the great assumption was that the court should be extremely restrained regarding constitutional change that affect its own powers. Why? Because otherwise it seems as if the court itself is abusing the doctrine to elevate its own powers, etc. So the accepted understanding was that courts should be extremely restrained when it comes to their own authorities, when applying the doctrine. We actually argued the opposite. Perhaps in these times, courts should be especially aggressive when it comes to reviewing changes to the judicial branch. And I'll give you just two examples from recent years. In 2014, in Bangladesh, there was a constitutional amendment that gave the president the authority to remove judges with the support of 2/3 majority in parliament. The court said, no, you are now violating one of the fundamental features of the Constitution. This is an unconstitutional constitutional change. A year later, in India, there was a formal constitutional change to the way that judges are appointed. Basically, let's not drag on the details, but basically the change was that instead of the judges selecting their own, they wanted to move to a more deliberative and inclusive and democratic committee that would select judges, something like the Israeli system. Nonetheless, the court said, no, you are now undermining the basic structure of the Indian Constitution. You are now violating judicial independence. This is an unconstitutional change. And various scholars, including myself, have criticized this judgment because this is not a really fundamental abandonment of the basic structure of the Constitution. No, not according to the traditional understanding of the doctrine. However, in retrospect, and in the context of abusive constitutionalism, I think these courts were actually right. Even minor changes that would undermine judicial independence are actually bad and should be blocked in order to later protect other measures undermining democratic institutions. So let me just wrap it all and finish. I think first that I need to maybe emphasize that I think that ideally the way to battle abusive constitutionalism, as we see nowadays, is through constitutional design. We need to design constitutions ex ante in an escalated manner that would be very difficult to undermine the most important features of the democratic order. But this is not the case, right? We're facing existing constitutional orders, and here I think basic assumptions, again, must be reconsidered. Instead of using judicial doctrine to protect against a revolutionary constitutional amendment that would establish, let's say, a fascist regime, we need to adapt the doctrine to existing constitutional practices that actually utilize incremental and subtle amendments to dismantle the democratic order. Thank you very much.